Amend this bill to the House.
Question is that the motion be agreed to. I call the honourable member Charles Chauvel.
Thank you, Mr Speaker. Mr Speaker, I hope that the Minister doesn't have cause in the years to come after he's left this House permanently to regret the last paragraph of the speech that he's given, where what he did was give us an assurance that this legislation would not deleteriously affect those most in need of assistance from the Crown when they are accused of a crime. So I want the House to be very clear about what we are doing today if we read this bill a first time. Because the bill is couched in very comforting terms. It sounds innocuous. Oh, we're just reviewing thresholds. We're applying the civil threshold to minor criminal matters. Nonsense. We're doing something much more draconian than that, and I'm going to spell out what this bill would do. Oh yes, well, Mr Henare might like to read the Crimes Act because, well, you know, Mr Henare, when your constituents come to you in your office and say, Toe, I can't get legal aid because your government's removed my entitlement to it, what are you going to tell them?
Order.
Mr Speaker, here are some of the offences that are now going to be put beyond the entitlement that people have to legal assistance. All that needs to happen is anyone needs to be accused of one of these crimes or offences and there'll be no entitlement if they earn more than $22,000 a year. That's the National Party's new definition of the rich. Most of the offences in the Summary Offences Act. Distributing indecent material, indecent act in a public place, criminal nuisance, misconduct in respect of human remains, concealing the dead body of a child, injuring by unlawful act, aggravated assault, assault with intent to injure, assault on a child or by a male or on a female, common assault, possession of offensive weapons or a disabling substance, unlawful use of interception devices, unlawful disclosure of private communications, making, possessing and publishing intimate video recordings, theft of property worth under $1,000, attempted conversion of a vehicle, being disguised or in possession of instruments for burglary, receiving stolen property worth under $1,000, making, selling or distributing or possessing software for committing a crime. Many more, sir, actually, under the relevant legislation. These are serious offences, and if somebody is accused wrongfully of one of these offences, and we all know it happens, if they're not earning over $22,000 a year, then they're not going to have anywhere to turn to for assistance for their defence. What are they going to do? They'll plead guilty. They'll go to jail. Innocent people, as a result of this legislation, are going to go to jail, as if we weren't locking up enough people in this country already. And Mr Henare, I say again to you, what are you going to say, Mr Henare, to your constituents when they come to you and say, we haven't got a bean, we're accused wrongly of a serious offence and we can't get any help? Because that's what Parliament will be doing today if we assist to pass this legislation. Let's just not be in any mistaken frame of mind about what this proposal means in practice. Sir, it goes further than the criminal side because it deals with civil matters as well, and it imposes that savage threshold, $22,000 a year of income. That's, again, the definition of rich, according to Mr Power. I think that's pretty rich myself. But if Kiwis are earning $22,000 a year, they won't be eligible for legal aid in civil matters unless there are exceptional circumstances. So again, what happens if your neighbour is sued and your neighbour doesn't earn that much and your neighbour needs a lawyer to help them out? They're wrongly sued, they're named to a civil action and they shouldn't be a party to that civil action, but they can't get assistance to defend themselves because, again, that's what the effect of this legislation is going to be. It's unconscionable, sir. People who are, through no fault of their own, caught up in civil actions and civil proceedings, if they don't have enough money to defend themselves, will be in no position to avail themselves of the services of a lawyer to get them out of that position. That is not a position that this Parliament should ever countenance putting any fellow Kiwi into. It is shameful, and sir, we should reject the proposition that's contained in the legislation that would advance that position. There's another matter that I'm troubled about in respect of the civil justice provisions in this legislation, and that's in respect of applications for personal care, protection or welfare issues where you've got a vulnerable person like a child at risk, a person at risk of domestic violence, a mentally ill person or a refugee. Now those restrictions apply to those people as well when they need to seek legal aid in order to get an application in respect of their personal care or property or welfare. Admittedly, there are some hardship provisions in the legislation, but again, let's be in no doubt about the effect of this legislation. Vulnerable people who need to instruct a lawyer in order to seek the protection of the courts, a fundamental right of anybody in New Zealand, will be prevented from doing that by this legislation. And no amount of yelling, screaming and interjecting by Mr Henare is going to change that sad fact. And I hope that he doesn't vote for this legislation, because we all know which New Zealanders, which most vulnerable New Zealanders, are going to be adversely affected by these provisions. If that wasn't enough, sir, there's a user charge contemplated by this legislation. We heard from the Minister it would be $100, and the bill provides that if you can't pay the $100, then you'll be able to pay interest until such time as you can. And in calculating your net value for your entitlement to seek legal aid from the government, guess what's going to be able to be taken into account under this bill? Your personal items of clothing, your household furniture, your household appliances, and your workers' tools of trade. They're all going to be able to go into the mix when you fill out the form to decide whether you're poor enough to get legal aid from the state, either because you've been accused of a crime and you want to defend yourself, or because you've become party to some civil litigation and you want advice on how to get out of that, or because you're a vulnerable person and you need to seek the protection of the court. I think we should be ashamed of these provisions. You'll have to say what the vacuum cleaner's worth, what the couch is worth, what your jeans, what your jacket is worth. This is the sort of level that we've sunk to under this minister and this government when it comes to something as fundamental in this country as access to justice. And finally, sir, there's a provision concerning family law. When, as members will know, there's a relationship dispute and a child is involved, the court appoints a counsel to represent the child. Well, this bill is going to require the parties to family law disputes to contribute to the costs of that counsel. What if they can't afford to do that? Does this mean either that they'll have to suffer substantial hardship, or alternatively that the child will miss out on representation, a fundamental part of the system that we know it in family law cases? So the Minister talked about a crisis in the funding of legal aid. I sat in the former Minister of Justice's office when she was meeting with the President of the Law Society 4 years ago, after the previous government increased the legal aid entitlements available to lawyers for the first time in 20 years. It wasn't a lavish increase, it was a modest one. It just about kept enough providers in the system to continue to provide the services that are required. We can do better than this. We can do better than savage cuts to the entitlement rates at which people who need access to justice with assistance from the state can access that assistance. We can do better at recovering grants of aid, treating it as more of a loan than a grant itself. There are many, many other ways that we can be fiscally responsible while ensuring that we retain people's access to justice as a fundamental right. And sir, I implore the House to consider those alternatives rather than to pursue this bill.